This is a story from a real case that demonstrates why, on a particular set of facts, TV licensing letters might amount to harassment. Stick around and listen to this one. So this is a case from 2018, and parties called Worthington and Parkin against the Metropolitan Housing Trust, a housing association. In the judgment of this case, His Honour Judge Owen QC, as he then was, found that the defendant housing association had unlawfully harassed two of its housing tenants. The tenants in this action had been assured tenants since 1997 and 2000 respectively, and for quite a bit of time they'd been worried about antisocial behaviour in the area. They approached the housing association for consent to install CCTV equipment for the purposes of monitoring their own security. They also set up a residents group and a website on which they would post evidence of behaviour that they considered to be unacceptable. However, other residents of the estate complained that all of this activity was against their right to privacy. For example, the CCTV, they complained, infringed on their privacy rights, and that photos of other residents had been inappropriately taken and uploaded onto the website. Oh, and just as a brief interlude, I'd like to thank everybody that used my link for Octopus Energy to hop over and switch your energy supplier. Each of those will be receiving £50 credit on their account, and for full disclosure, it was a referral link, so I will get a benefit as well. I will drop that link in the description to this video in case you want to switch as well, and you'll gain £50 by doing so. But in the meantime, back to the video. Accordingly, senior employees of the housing association then had meetings with the claimants in this case, the ones that had installed the CCTV equipment, to raise the concerns and to explain why other residents were concerned about these CCTV and the photographs taken, etc. Later in the same year of 2007, the claimants were advised to remove the CCTV equipment. However, Miss Parkin refused to do so. The situation escalated somewhat, with the estate manager upping the efforts to attempt to get this CCTV equipment removed, including asking police officers to visit the home, drawing up a petition against the claimant's activities, which were apparently signed by 80 different people, and even providing several statements that had apparently been prepared by other residents. The estate manager for the housing association instructed solicitors to send letters to both Miss Parkin and Mr. Worthington, accusing Miss Parkin of infringing privacy rights with the use of the CCTV, and accusing Mr. Worthington of using CCTV at his property as well. Both of these allegations, however, were incorrect. The judge in the case found that Miss Parkin had only used CCTV for the purposes of her security and not to invade the privacy of her neighbours, and that Mr. Worthington had never installed any CCTV cameras at his property. However, whilst all this was going on, in the October, the housing association sent both of the claimants letters stating that it intended to evict them from their homes as a result of the misuse of CCTV. Both of these letters had some serious flaws. In November of the same year, the solicitors sent further letters threatening legal proceedings again if the CCTV wasn't removed. The claimants responded to deny the allegations, but in January the solicitors wrote again, informing the claimants this time that an application for an injunction to enforce the terms of the tenancy agreement would be made unless she removed the CCTV equipment within 7 days. Now, although the claimant did not comply with this request and did not remove the CCTV equipment, no injunction application was filed at court. In other words, the solicitors made a threat for the application if the CCTV wasn't removed. It wasn't removed, but they made no application. And despite no application for the injunction being made, Miss Parkin was not informed about this until the middle of that year, some 6 months later. But also in January, Mr. Worthington received a letter to say that legal proceedings were in progress. But obviously that was not true. There were no legal proceedings in progress because the sending of a letter is not in and of itself legal proceedings, although that's what he was led to believe. But as I say, no legal proceedings were live at that stage, and no legal proceedings were filed at all. But you may have worked out by now that Miss Parkin and Mr. Worthington were the claimants in this case against the housing association. In other words, they made claims for harassment by the housing association for threatening legal proceedings, telling them that legal proceedings were underway, which they were not, and never in fact following through on those legal proceedings as they were so threatened. So coming back on point, and what does this all have to do with TV licensing? Well, many people over the last few weeks and months and indeed years have sent me emails to complain that they receive letters telling me that they receive all sorts of different letters from TV licensing telling me that their house is under investigation. It has been scheduled for a visit from an enforcement officer, which sounds quite serious. Letters stating that they are planning to take further action against them with an urgent notice attached. And in many cases, not just one or two or three, but several letters, month in, month out, all of which to say that the house has had a code attached to it, that there's an investigation open, that there's an enforcement visit scheduled, and all these sorts of things. However, if we were to apply the same facts and reasoning and legal analysis as the Worthington and Metropolitan Housing case, we could potentially conclude that all of these letters might amount to harassment. If indeed it is taken to cause alarm and distress, as provided under Section 1 of the Protection from Harassment Act of 1997, which states that a person must not pursue a course of conduct which amounts to harassment of another and which he knows or ought to know amounts to harassment of the other. And Section 7.2 states that harassment includes alarming the person or causing the person distress, and a course of conduct described in Section 7.3 in relation to a single person, conduct on at least 2 occasions in relation to that person. So obviously 2 letters or more, or certainly half a dozen letters, which might reasonably be causing some person alarm or distress, could well, on the same analysis, amount to a course of conduct that causes someone alarm or distress, which, as defined in law, is harassment. So unless and until a case like this gets to court on a particular set of facts with a particular set of letters and circumstances, threats of enforcement action, threats of a visit, threats of further action, as some letters have detailed, with no further action actually being taken, no enforcement visit happening, no legal action being filed or taking place, we may not know for sure whether or not a court would uphold a claim of harassment against TV licensing in those circumstances. However, it is entirely possible, given the right set of circumstances, applying the same analysis as in this very case that I've told you about, that the actions of TV licensing could well amount to harassment. It would only take one person or one group of persons with a like claim in harassment for receiving so many letters to go to court to ask the court to uphold a claim in harassment on the same analysis of this very case, in that they've received lots of letters on 2 or more occasions, that they have reasonably been caused alarm or distress, which the Office of TV Licensing ought to know might cause alarm or distress. Indeed, in their own wording, they do describe that the letters get increasingly more serious in tone to encourage somebody to buy a license, if they need one. But if they don't need one, they still seem to receive these letters. Now, I have to caveat all of this with the following, and to say that many people do say that they make the declaration that no license is needed and they hear nothing further from them for another 2 years. Doubtless, that would be the argument used by TV licensing in the event that there were a claim brought, because they do provide that as an option. However, a very interesting point is this. There is no legal compulsion upon anybody to provide that declaration that no license is needed at the address. The law does require that you have a license if you watch or record live TV, or use BBC iPlayer, or install any apparatus for that purpose. However, you do not legally need to declare that you don't need a license. So if you don't do that, but you still receive all of these letters and you are caused alarm or distress, then you might want to seek legal advice to bring a claim in harassment, because it is entirely possible that on the same analysis as this case here, a judge might well uphold such a claim. I thought that was a very interesting intellectual analysis and comparison between this case and the practice that is sending out these letters by TV licensing. Now, it also has to be said that I'm not entirely against TV licensing sending out letters. Of course, they are encouraging people to buy a license and to avoid breaking the law, which I support. But I do think that the wording of them could be changed very slightly so that it doesn't cause anybody alarm or distress, and therefore those people that genuinely do not need a license would not be caused alarm or distress if they do receive these letters but don't need a license. So I hope you followed that analysis. I hope you found it interesting. Please do bop the like button and subscribe. And as always, thank you for watching.